Tipp FM's Tipp Today.
With Slattery's Garage, Puck On. Over half a century driving the people of Tipperary and surrounding areas with quality, reliable and economical vehicles, new and used. Call the sales team today to discuss your next car or van on 067 24111.
Well, you're very welcome back to Tipp Today with me, Stephen Gleeson, in here for Fran at the moment, and I hope you're enjoying the show. Busy show, a lot in on text as well, and we'll come to them in a little while. But I'm delighted to be joined here in studio by Gillian from Lynch Solicitors. You're very welcome to the show.
Thank you, Stephen.
And Gillian, I suppose we've a number of things to get through today, and we'll be discussing probate litigation.
Correct, Stephen. Yes, there's been a huge increase in this type of work over the last couple of years, and even this year there's been a number of big High Court decisions on issues that arise where people challenge wills or disputes regarding wills, or where wills aren't properly made. So challenges. So probate litigation is essentially challenges to wills.
And I suppose the death of a loved one is a traumatic time in anyone's life, but when someone feels that they've been cheated out of an inheritance, it can create huge division and discord within the family.
Absolutely, and it can lead to families falling apart, so I suppose we would always urge at an early stage family meetings, mediation, but unfortunately that doesn't work in some cases, and we end up in litigation.
Okay, and what are the common grounds for challenging a will if that decision is made and you're not happy with it and you feel you have to?
Yes, absolutely. So there are a number of grounds for challenging a will. One ground is the validity of a will. Another ground is whether or not the will makes proper provision or fair provision for a spouse or for children. Another one is if there's executors' disputes. So if the executor doesn't progress the taking out of probate, that can lead to another challenge. Another would be undue influence, claims of undue influence.
Okay, and what would make a will lack validity?
And I suppose that's why it's important to always go to a solicitor or come to us to do your will, okay? Because there are very strict formalities that have to be followed in a will. For example, it has to be dated, has to be witnessed by two people. The people who witness wills can't get a benefit under the will. So there was a recent High Court case this year where somebody witnessed a will and they were also receiving a benefit. So that benefit lapses. You have to, it has to be witnessed by two people, and it has to say there are rules. For example, there has to be a residuary clause. So there are formalities that have to be observed.
It's a hugely traumatic experience then when you're dealing with everything and you've the emotion of the bereavement as well on top of that, and it can be particularly difficult if there's a will made and if a spouse has been excluded from the will, because it happens.
Yes, absolutely, it happens. So if a spouse is excluded from a will, they have an automatic standing in terms of what they are legally entitled to inherit. They have what's called a legal right share, and it's embedded in law. So if somebody does a will and they exclude their spouse, the spouse can insist on their legal right share, which is 1/2 of the estate if there are no children, or it's 1/3 of the estate if there are children. And that can blow the rest of the will out of the water, and I suppose that's a term that we would use. If a spouse steps in and takes their legal right share, the rest of the will is blown out of the water. So that is set out in law. Cohabitants, and I spoke to Fran about this 2 weeks ago, cohabitants don't have the same rights, but they have a right to look for provision, but it's not embedded in law that a cohabitant has a legal right share.
And you mentioned there about the spouse's legal right share. Is there any exceptions to that?
Yes, there are exceptions, and there's one notable case that dealt with the exceptions, and that was the famous case of Catherine Nevin, the Black Widow. And I'm sure a lot of your listeners that name would be familiar because that case was in the courts for years. So there can be exceptions. So one of the exceptions is unworthy to succeed, and the legal right share can be lost if the spouse is convicted of murder, manslaughter or attempted murder, or convicted of another type of offence which carries a sentence of more than 2 years. So there are limited exceptions, but generally murder, manslaughter or attempted murder would be what would fall into that exception.
Oh, they're serious things as well. And undue influence, tell me a little about that one. What are the common signs of that you'd look out for and that you'd have?
Absolutely. I've been involved in one or two of these cases over the last year or two. So typically undue influence, somebody has to make positive proof that the testator is the person who does the will. They need positive proof that they were pressurised to the extent that they did not do the will under their own free will. Okay, so merely convincing somebody or persuading somebody to leave you something, that isn't undue influence. So again, when we do wills for people, if it's an elderly person, generally they may be brought to the office by a child. That person would not sit in on the will. We may meet somebody a couple of times to make sure that that they're doing it of their own free will. I was involved in one case previously where it involved somebody literally being befriended by somebody and then being smuggled essentially out of a nursing home to a new solicitor that they'd never met. And that was a case where there was an allegation of undue influence.
Okay, so very serious one as well. And we spoke about spouse being left out of the will, and can be equally traumatic, I suppose, if a child is excluded from a will.
Yes, and interesting that you say that, because children don't have any automatic inheritance rights. So a spouse is their legal right share. Children don't have automatic inheritance rights, but they can bring what's called a Section 117 application. So that is a court application saying that they were not properly provided for by their late parent. And there's a range of things that a court has to look at. It has to look at whether that parent failed in their prudent and moral duty to the child. So they'll look at what the child did, where was the child in life now in terms of income, expenditure, assets, and should the child have been more properly provided for in a fair way. So again, when we're doing wills for people, we will take detailed instructions. Why perhaps a child isn't being included in a will. It may be that they got a farm. It may be that they were funded through college. It may be that they got specific gifts that the other children didn't get. So it's very important that all of that information is gleaned or is documented somewhere in the event that there is a Section 117 application.
And Gillian, then if that situation arises where someone isn't happy with it and they decide to challenge the will, who pays for that, or what's the scenario regarding that?
Yeah, so these challenges are expensive. Certain types of challenges, such as Section 117, if the assets are below a certain amount, they can be brought in the circuit court. But a lot of other challenges have to go to the High Court, and there's a specific judge who actually deals, a probate judge, who deals with all of these cases, such as the amount of them. Generally, generally in litigation, costs follow the event. But in probate litigation, the costs can come out of the estate if it was reasonable to bring this challenge. And again, that can significantly reduce the pot. It can reduce the estate, which can have a knock-on effect for everybody. Then there's one certain type of challenge which costs may not come out of the estate, which is where there's an allegation of undue influence. So cases involving allegations of undue influence would need to proceed with caution. You need to make sure that you have that absolute positive proof.
Texter here, if a child hasn't had contact for years, does that make a difference, is a question?
No, it doesn't, no. And sometimes that may actually assist with a case because they may not have been properly provided for by the testator. Okay.
And what... another one here, what can a beneficiary do if an executor doesn't take out probate and they can't get their inheritance? What would happen in that scenario?
Yeah, that's something we come across quite regularly. So there is what's called the executor's year. So the executor is the person who's nominated under the will to essentially administer the will and make sure that everything is done in accordance with the deceased's wishes. So they have a year to take out probate. If the year passes and they haven't advanced, you can then, so a beneficiary under the will can then can seek to have them removed as executor, because obviously they're waiting for their benefit. They can seek to have them removed as executor, and then there's, I suppose, a hierarchy or a chain in terms of who is next entitled to step into those shoes. So the person next entitled to extract the probate is whoever receives the residuary benefit under the will. So every will have a residue clause which says all the remainder of my estate I give to whoever. So those people then can step into the shoes and proceed to extract the grant of probate.
And just say that a situation arose where there was a dispute, a probate dispute, could it be settled outside of court to cut the costs?
Absolutely. It can be settled. There can be a deed of family arrangement where everybody can agree this is what we're going to do. We're not going to abide by the terms of the will, but we're all in agreement, and then we formalise it by way of a deed of family arrangement, which is an agreement. It can be done by mediation. Sometimes if proceedings are issued, parties will realise, oh my God, this is actually going to reduce the pot that's there. We're going to have to sell assets to pay the costs involved, and sometimes that'll bring parties to the table.
Okay, and if someone was granted a right of residence but refused to take it up, would that be an issue as well?
Well, if nobody has to take a gift under a will. You can always renounce your gift under the will. You're not obliged to take it.
Okay, that was another message in, and one here. What steps can I take if I believe a will has been forged or tampered with?
Okay, so and again that goes back to the validity of a will, and a challenge can be made on the validity of a will, and if somebody thinks the will has been forged or challenged, it may involve forensic handwriting experts, and there's a recent case on that. The solicitor's notes who did the will, they'd all be very relevant. Okay,
good few messages coming in along those lines, and a lot of questions for you today, Gillian.
On this interesting topic.
Yeah. And if a solicitor is involved in this, how do they communicate this with other parties? Because it's such an emotional time if someone is bereaved.
Yes, so I suppose generally the solicitor will only be communicating with the executor, because the executor is the person who's been appointed under the will to conduct business in accordance with what's set out in a will. So generally we would be trying to keep costs down, and we would be generally communicating with the executor.
Yeah, someone's saying that what do I need to bring if I'm having a meeting with a solicitor about a dispute?
Well, I suppose the will, if they have a copy of the will, any documents that they have, you should always bring those for the first attendance.
Yeah, and if you have these cases go on and on, I'd imagine, do they?
They can go on, and often people actually don't have a copy of the will, because it's the executors who are only legally initially entitled to receive a copy of the will. Sometimes then the executors will instruct that you release a copy to the beneficiaries, but it's really only after the grant of probate issues that the will becomes a document of public record, and where a grant of probate has issued, the will is available for the public to request through the court service.
Okay, so I suppose if the information isn't coming from you directly, there's always room for other things getting involved and people just adding little lines here and there.
Absolutely. So I suppose clear communication between family members is very important, because obviously something that could start small can obviously snowball then and end up in contentious litigation.
All right, there's a lot in, and the texts are still coming in. Hi Gillian, probate is done, but they're looking for a document that may not exist. How long could this go on for?
I suppose it depends on what the document is. So I don't know what that document is. So should sit down with the solicitor and see what the document is. Why isn't it available, or when can it become available?
Also, if an asset is sold and the solicitor has the funds in their account, who gets interest on the funds if there is?
Well, that will be a matter for when the estate accounts are done, interest to be accounted for in the estate accounts.
Oh, could talk about this, I'd say, Gillian, all day. A lot of messages coming in for you on that. So it is a very emotional thing, I suppose. And just, as you said there, clear communication, that's probably the basis of a lot of this.
Yeah, absolutely. And, a lot of disputes can be avoided and costs saved if there is clear communication.
And it's something that you encounter regularly?
We encounter a lot, and actually one thing that we encounter a lot that I didn't mention was capacity to do wills, where people assert that the person who did the will had lost mental capacity. So when we're doing wills again, we always take very clear instructions. If we've any concerns, or if we believe there may be a challenge about capacity at a later stage, we would get a medical report from their treating doctor. So it's important to go back to basics and that the will is done right from day one.
Brilliant stuff. Gillian from Lynch Solicitors, many thanks for joining us this morning, and you've helped a lot of listeners here from what I'm seeing on the text.
Thank you, Stephen.
Thanks, Gillian. We're going to take a quick break. Back with more after this.
Tipp FM's Tipp Today.
With Slattery's Garage Puckon. Now is the time to pick up your next van. From the award-winning Peugeot Partner van to the Expert and the load-lugging Boxer van. We have big vans, high roof vans, long wheelbase vans. You'll find them all at Slattery's Garage Puckon. See slatterysgarage.ie.